Florida's probate laws just changed in 2025. And if you've inherited a property or you're part of a blended family or you want to protect your loved ones, you need to understand what's new and how this affects you. Hi, I'm Caroline Castillo, a certified probate real estate specialist here in Florida. I help families through often an overwhelming process of settling estates and selling inherited property. Now, before we dive in, a quick heads up. This is not a video meant to give legal advice. It's a simple overview of recent probate laws changed here in Florida, meant to help you better understand how these updates might impact you, especially when real estate is involved. Let's go ahead and go through these changes together. Now, the first major update is increased protection for surviving spouses. So in 2025, Florida made it official. A surviving spouse's own property is now exempt from creditor claims. But what's even more important is that the law now allows surviving spouses to waive their rights to inherited property after a spouse passes away. Why is this helpful? Well, let's say a husband passes away and wants his assets to go to his children from a previous marriage. His current wife, the surviving spouse, can now waive her automatic inheritance rights, making sure that those assets go directly to his kids as it was intended. So this is especially powerful for blended families where everyone wants to avoid conflict and protect the relationships between stepchildren and stepparents. Now, the second big change, Florida has now strengthened the protection for heirs and beneficiaries. The rules got a lot clearer on how and when a will can be contested, and the longer notice periods to ensure that everyone has enough time to be informed and take action. This is huge. So if a beneficiary, when you have more time to review your rights and respond, and if you're a personal representative or an executor, it means fewer surprises down the road and overall a smoother probate process. Next up is a bigger change more on a federal level, but it still matters here too, especially if you own a high value property or your family business. So starting in 2026, this was part of the big beautiful bill, the estate and gift tax exemption has been made permanent at $15 million per person or $30 million for a married couple, with inflation adjustments moving forward. So while most families won't cross that threshold, it is important to know that they are locked in, giving you peace of mind for long-term wealth transfer and legacy planning. What should you do with all this information? Well, if you're in a second marriage or you have a blended family, talk to an estate planning attorney about the post-death waivers and how to ensure your wishes are honored. If you're currently going through probate, make sure that your attorney and your real estate team understand these changes. Outdated advice could cause delays or disputes. And if you've recently inherited a home and you don't know what to do next, this is your moment. Take a breath and get the support. To make things easier, I created a free guide in the 2025 Probate Law Update Guide. It's going to break down everything in plain English, and it includes a checklist, so you can use this when dealing with your inherited property. You can download it using the link in the description, and if you'd like help with your unique situation, visit probatepropertyangels.com and book a free 15-minute consultation. And if you hit the subscribe button and click that bell so you won't miss my weekly videos for Florida families navigating probate. Remember, I'm here to help you. Your inheritance is a blessing and not a burden.